I am Richard Avermenko, the director of the Center for the Study of Liberal Democracy, a professor of political science, and also integrated liberal studies here at the University of Wisconsin. The CSLD, the Center for the Study of Liberal Democracy, is a think tank on campus here at UW. We're a think tank that promotes the appreciation for and the critical understanding of the cardinal principles of liberal democracy, including constitutionalism and the rule of law, the meaning and scope of freedom and free markets, and the centrality of individual rights. Originally established to pursue and preserve First Amendment liberties on campus, the center has grown, especially over the last 10 years. With the generous support of our donors, we now sponsor undergraduate fellows, graduate fellows, postdoctoral fellows, visiting scholars, and guest speakers. We sponsor 3 journals, 2 scholarly and 1 for undergraduate research. And if there are any undergraduates in the room who would like to step up and run Sifting and Winnowing this year, talk to me afterwards because we need more people on that journal. We host speakers, sometimes controversial speakers, usually in partnership with student organizations. And we are able to organize events like this one because we have a very generous network of donors. And this particular event was sponsored by the Jack Miller Center. And we are grateful for the money they give us for this celebration of Constitution Day. You might be aware that President George W. Bush back in 2004 signed a bill called Public Law 108-447 that designates every September 17th Constitution Day. Institutions of higher education that receive federal money are required to prepare a program to inform students about the Constitution. Responsibility for complying with this law here at the UW falls on the Provost's office. And for a couple years, independent of the Provost's office, my colleague John Zimbrunnan with his American Democracy Forum hosted Constitution Day events. The law school has stepped up on occasion. They will open, and there may well be today and this week classes on the Constitution open to the public. But we at the Center for the Study of Liberal Democracy have gladly taken up this responsibility. And this year we are delighted to host Phillip Muñoz, who's sitting over there. Dr. Muñoz is the Tocqueville Professor of Political Science and a concurrent professor of law at the University of Notre Dame. There, he's the founding director of Notre Dame Center for Citizenship and Constitutional Government, which hosted me last year for my sabbatical while we spent the year in South Bend. If I haven't said publicly, thank you. Dr. Muñoz writes and teaches across the fields of constitutional law, American politics, and political philosophy with a focus on religious liberty and the American founding. He won a National Endowment for the Humanities Fellowship to support his most recent book, Religious Liberty in the American Founding, Natural Rights and the Original Meaning of the First Amendment Religion Clauses, which came out last year. He's many articles related to the project and as other scholarship have appeared in the very best of political science journals, including the APSR, the Harvard Law Review, the Notre Dame Law Review, American Political Thought, Journal for Constitutionalism, and on and on. I have a list of the many accomplishments that Professor Muñoz has on his CV, but I would just like to highlight that he's a really personable fella. And his center has raised over $20 million in the last decade or so to sponsor events like this. Ladies and gentlemen, Professor Phillip Muñoz.
Good afternoon. I'm thrilled to be here in Madison. My mother is actually from Fond du Lac, Wisconsin, which is just up the road. So I've always thought of myself as a native Wisconsinite. I love cheese. I hate the University of Michigan. So I feel right at home here. I'm sorry, I was texting during the introduction because as Professor Avermenko said, this was the Constitution Day event, and thank you for hosting me as your Constitution Day speaker. I was texting my assistant saying, what are we doing for Constitution Day? It turns out the penalty for not hosting a Constitution Day event is that the university loses all of its federal funding. So I'm saving you a lot of money by speaking here today. Let me thank Dr. Avermenko, his staff, everyone at the Center for the Study of Liberal Democracy. I know the center well, and I very much admire its work and its director. And the center really is one of the leading centers for the study and preservation of liberal democracy. If there are any supporters here, benefactors of the center and its efforts. You should do everything possible to keep the center here and flourish and keep its leadership here. Let me also thank the Jack Miller Center for sponsoring today's talk. Okay, so I haven't really done this talk before, so I'm going to try to go through it relatively quickly, in part because I'm very curious to know what you think. And hopefully, having not done it before, I'm a little bit nervous about how long or short it is. We'll find out together. But I'm eager for your feedback. I'm going to start with two Supreme Court cases. The first was decided in June 2022, so just over a year ago. It involved a public high school football coach named Joseph Kennedy. Starting with his first game in 2008, Coach Kennedy took a knee in prayer on the 50-yard line after his team's games. This was coached at a public high school. In 2015, so several years later, after he started this practice, his school district found out, and it instructed Coach Kennedy that he needed to stop his post-game prayer practice, or at least only do prayers after all the students had left the stadium. Coach Kennedy didn't much like the district's demands, and there was some factual disagreements between the parties in the lawsuit. But the end result is that on account of the district's demands and his not willingness to follow it, he continued to pray, and then he was relieved of his duties. This led him to sue, and last year the Supreme Court decided the case in Kennedy versus Bremerton School District. Okay, a second relatively recent case. In 2018, the Supreme Court heard a case brought to it by Mr. Jack Phillips. Phillips, you might remember, was a Christian, or is a Christian cake artist. That's his term. He owned Masterpiece Cake Shop. Phillips refused to design a cake for Charlie Craig and Dave Mullins. They sought to procure a cake design, his design services, for their same-sex wedding party. Phillips refused to design the cake on account of his Christian beliefs. Now, let me just add here, there's a lot of young men. Do you have any idea what a wedding cake, women don't answer, but men, what does a wedding cake cost, do you think? What does a custom wedding cake cost? Yeah. Yeah, okay. Well, what do you think?
It's in the hundreds.
In the hundreds, or thousands, or tens of thousands of dollars. He was a cake shop artist. Craig and Mullen filed a discrimination complaint. The Colorado Civil Rights Division found that Phillips and his cake shop, Masterpiece Cake Shop, violated the state's Anti-Discrimination Act, which prohibits in places of public accommodation discrimination against same-sex couples. Civil Rights Division ordered Phillips to change his business practices. Phillips appealed Colorado's judgment, and his case too wound up before the Supreme Court. So Kennedy and Masterpiece Cake Shop, the two cases I've just mentioned, they're noteworthy insofar as they made it to the Supreme Court, but they're also typical insofar as they exemplify the core divisions in America regarding religious freedom and the Constitution. To speak in broad terms, and I'm overgeneralizing here, but many progressives, certainly not all, but many progressives tend to emphasize freedom from religion, especially freedom from the influence of traditional religious sexual morality. Again, many, not all, but many progressives contend that Coach Kennedy should be prohibited from praying, at least in front of students, lest his players feel coerced to pray with him. When the state endorses religion, especially in the context of a high school, public high school, it can easily psychologically coerce or pressure students to pray, and this, of course, is unjust, it encroaches on the liberal conception of individual moral autonomy. So to preserve autonomy, again, many progressives, not all, but many, contend we must overcome longstanding forms of oppression, including religious condemnation of homosexuality. Whereas public school kids must be secured from unwanted prayers, the market must be made secure from invidious discrimination. The right to be free from religion means Coach Kennedy should be prevented from praying in public, and Mr. Phillips should be made to design the cake. Now, social conservatives, again, I'm generalizing, many social conservatives, by contrast, say religious liberty is the freedom to be religious, especially the liberty to live and act in the public square according to one's religious convictions. Religious liberty, most conservatives say, means Coach Kennedy has a right to kneel down in prayer and that Mr. Phillips has a right not to make the cake. Given these seemingly contradictory commitments, freedom from religion on the one hand and freedom for religion on the other, what are we to make of our first freedom? And what, if anything, might our founding fathers shed on the Constitution's original meaning of religious liberty? Does the Constitution's original understanding offer a does the Constitution offer a coherent understanding of religious liberty, one that we might consider going back to today in our increasingly morally and religiously pluralistic society? Is religious freedom freedom from religion or freedom for religion? So I believe the founding fathers have much to teach us, but that their lessons don't fit neatly into our current political categories. I'm going to try to explain why I think, at least in their thought, freedom from religion and freedom to practice one's religion are both aspects of the founders' understanding of our inalienable natural right of religious liberty. But the freedom our founders secured in our Constitution was much more limited and much more democratic than either contemporary progressives or contemporary conservatives recognize. So I'm going to argue before you that the founders had a robust but quite limited understanding of the right to religious freedom. Unlike the court today, the founders conceived religious liberty in jurisdictional terms, jurisdictional limitations on state powers. Founders held that there are just a few things government could never do vis-a-vis religion. But when government acted within its sphere of competence, when it acted for the common good, the civic common good, religion and religious individuals could both be benefited and disadvantaged by the law. Okay, so I'm going to try to do these three things today. I should know, I'm teaching a church state class. It takes me, usually 3 or 4 weeks to try to do what I'm going to do in 30 minutes. So I say that I'm just going to make all sorts of assumptions and make all sorts of statements without the requisite argumentation. Feel free to ask me to elaborate on any of these points. Okay, let me try to present the founders' understanding of the natural right to religious liberty. I think we don't understand the founders today because we've forgotten our basic constitutional principles of government. The founders, like us today, used the language of rights, but their understanding of rights was different, perhaps even deeper and philosophically richer and more integrated with a robust notion of duties than our understanding today. We tend to think, again, this is a generalization, but we tend to think of rights as interests, especially interests that are especially important to us. So we say healthcare, to take one example, or freedom of speech, to take another. These are rights because we believe bodily health or the expression of one's opinions are necessary to live a decent life, we say. At the same time, we say that our fundamental rights, like healthcare or free speech, can be limited if governmental compelling interests are at stake and the government uses narrow means to restrict them. The underlying presumption in this understanding of rights, our modern understanding of rights, is that our rights come from the state. We think good government, it grants extensive rights to citizens because we believe the role of government is to satisfy our collective will and provide for individual needs. But the extent to which any particular right is available depends on it being balanced against other rights and other state interests. And this process of balancing, both giving and curtailing rights, that's what government, specifically the administrative state, and especially the judiciary, that's what they do. So that's our modern understanding of rights in a nutshell. The founders had a different understanding, at least of natural rights, and let me try to present that. Natural in this sense means the foundation of rights lies in our human nature. The natural right of religious liberty, in other words, is not granted by government. It's part of the natural fabric of the created moral order, an order in which rights and duties are reciprocal. A just government recognizes this natural pre-existing order. It does not create it. The founders held that our natural rights are endowed by our creator, not granted by the state. Founders also held that our rights were not opposed to our duties. Indeed, our duty to the creator is why we have a right of religious liberty among men. James Madison articulated this most clearly, and this is what he said. He writes, "What is here a right towards men is a duty to the creator. It is the duty of every man to render to the creator such homage and such only as he believes is acceptable." Because, excuse me, because first and foremost, we are children of the creator, our first allegiance is to him. I think I might be behind here. Sorry. Okay. The political institutions we create and the civic obligations we impose must recognize our pre-existing duties. This was the founders' understanding. So our politics must remain limited in respect to and deference to the higher claims of religious authority. We have, just to put it plainly, we have a religious right among men because we have a more sacred and sovereign duty to God. So for the founders, the right of religious liberty imposes limits on state authority. You can see this in the text of the First Amendment. It says Congress shall make no law prohibiting the free exercise of religion, establishing a religion. No law for the founders means no law. Congress, and then with incorporation, the states, Congress and the states can make no law because they lack authority to make such laws. Government officials have no authority to punish an individual for improper worship or to command an individual to worship. How or whether we worship, properly speaking, is no business of the state. It's not a direct concern of government. It cannot be because we, the people, never gave government that authority. That's what it means to retain, when we say we retain our inalienable rights. They're inalienable. We don't give them up. An inalienable right is a right in which government has no authority. This absence of jurisdiction, this is why the government can't issue, just to take an example, preaching licenses. Not all, but most professions are licensed. To go fish, you got to get a fishing license. To cut hair, you got to get a cosmetology license. To practice law, you got to get a law license. To be a doctor, you have to have a medical license. And these are all to protect consumers and to make sure that the people in these professions are fishing licenses, so people don't, take too many fish, catch too many fish, to preserve the fish for everyone. But government can't issue preaching licenses. Well, why not? Because we never gave government authority to do so. So the founders understood limitations on governmental, these religious limitations on governmental authority to be categorical. Again, that's why they declared Congress shall make no law. But this categorical or absolute character of religious liberty also means that scope is very narrow. When government acts within its proper domain, religious citizens can be accommodated from burdensome laws, but they have no constitutional right to be exempted from these laws. If government cooperates with religious institutions to accomplish otherwise valid civic ends, no constitutional barrier is trespassed. The founders understood the inalienable natural right of religious liberty only to require the state remain within its competent sphere. When the state is within its sphere, it can do things that both burden and extend benefits to religious citizens. Okay, let's try to think how, sorry, I'm way behind here. Trying to think of how to portray what I've just said visually. So the sphere on the right here is what alienates. That's what we give government authority over. The sphere on the left obviously is unalienable rights. Just if that seems confusing, we can talk about this later. Think of the right to revolution. You don't get a revolution license from the government. It's nonsensical. The right to revolution, I presume this would be a good example for Madison. The right to revolution, by its nature, is an inalienable right. Founders said the same thing about religious liberty. Okay, that's the founders' understanding. Let me try to contrast that with the modern court's understanding. Whereas the founders' approach focuses on jurisdictional boundaries, right? Drawing the circles properly, marking where the state has and does not have authority. The modern Supreme Court takes on a more managerial role. Rather than enforcing fixed rules, the circles above, the modern court has sought to achieve certain results within the circle. The court has not been an umpire, but rather a player in the game. The result the court seeks to achieve depends on who's in control. When the court's liberals dominated church-state jurisprudence, especially in the middle of the 20th century, they built a wall of separation between church and state. They read the Establishment Clause to prohibit government policies that advance religion, even if those policies had otherwise valid civic purposes. So in the most famous case from that era, this is Lemon v. Kurtzman, 1971, the court held that a Catholic school could not receive state funds to enhance the teaching of mathematics. Because the money, the court said, might end up funding some part of the religious education of the school, thus violating taxpayers' rights to be free from religion. For the same reasons, in more recent years, liberal justices on the court have voted to prohibit religious schools from participating in state-funded school voucher programs. A famous case here is Zellman versus Simmons Harris. That's 2002. Liberal justices have tended to vote to uphold state constitutional provisions that mandate the exclusion of religious institutions from schools participating in government programs. Justice Sotomayor, to give you a more recent example, there's a program in Missouri, there's a scrap tire program, so what do you do with tires, especially big truck tires after they're used, right? I mean, it's a terrible pollutant. And you got to do, you want to recycle the tires. So in Missouri, they came up with a program where they grind up the tires and then use them to surface playgrounds, because they're cushiony, right? And they said schools could participate this. So like if your playground's old, we'll resurface your playground using these recycled tires. So kids win, the environment wins, everyone wins. And so this school, Trinity Lutheran, which had an outdated playground, submitted a grant just like everyone, and they won, right? They were deemed worthy of participating in the program. A lawsuit was filed. Justice Sotomayor said, because they're religious, they can't get a new playground. Religious groups must be excluded from public benefits. That's the old freedom from religion approach. Okay. While liberals have stretched the meaning of the Establishment Clause, both liberals and conservatives have stretched the meaning of the Free Exercise Clause. The key case here is in 1963 at Sherbert versus Werner. And here the court said that religious individuals and institutions have a constitutional right to be exempt from laws that they find burdensome, except in the narrow case when the state is pursuing a compelling state interest, that's a legal term, and uses the least restrictive means to advance that interest. Again, those are legal terms, compelling state interest and least restrictive means. This originally was the liberal approach to the Free Exercise Clause. The author was Justice William Brennan, the dominant 20th century, second half of the 20th century liberal justice. The Sherbert rule was curtailed in 1990 by Justice Scalia, but the exemption approach to religious liberty is still championed and still effective in much constitutional law, and is championed today by the court's conservatives. The court's conservatives today say the proper understanding of religious free exercise is that religious individuals and religious institutions have a constitutional right to be exempt from laws they find burdensome. That's what Jack Phillips was advocating. In 2021, Justices Alito, Thomas, and Gorsuch, in a very, very long opinion by Justice Alito, said the court's older jurisprudence, which was overturned by Justice Scalia, should be reinstated. Okay. So again, this is, I don't know, these are not perfect. I had trouble figuring out. These are two separate. I should have done this on separate ones. So the two circles are not related. The blue circle is the liberal approach. That is, there's only one circle, not the two circles that I had before. There's only governmental power. And the liberal approach is to arrange that power. So secular interests govern religious interests. The conservative approach is just, there's also only one circle. But religious interests, for the most part, outweigh secular interests. This is what I call the managerial approach. Judges trying to manage church-state relations. They're playing within the circle. They're not adjudicating the two circle boundaries because there's no circle of non-alienated rights. Sorry, I should have done this slide differently. Okay, whether to build the wall of separation or to carve out exemptions for religious believers from otherwise valid laws, both liberal and conservative justices would interpret religious liberty to require special treatment for religious individuals. Special treatment administered by the judiciary, often in a case-by-case basis, using relatively vague standards. This managerial approach, again, shared both by left and right. In this managerial approach, jurisprudential liberals keep the public square free from religion whenever they deem it necessary. They employ flexible standards, such as whether the primary purpose of legislation is to advance religion, or whether it causes excessive entanglement with religion. I'm not summarizing my interpretation. These are the actual constitutional rules. Does this particular action cause excessive entanglement? Well, according to whom? According to whatever a majority of 5 justices say. Does government action psychologically coerce students to pray? None of these rules are clear, which means judges can use them whenever they want, in this case, to eliminate religion from the public square. Conservatives do the same thing, just they do it under the free exercise clause. Conservatives ask, whenever a law substantially burdens religion and the state lacks a compelling interest, these are legal terms, substantially burdens and compelling interest. When this occurs, when there is a substantial burden and not a compelling interest, religious individuals get an exemption from the law. How do we know if there's a compelling interest? What's the constitutional standard for a compelling interest? Whatever 5 justices of the Supreme Court say. I've given this part of the talk before, and lawyers hate it because they're not doing law. They use fancy terms to obscure what they're doing. They're just saying, we want this group to win and this group to lose. And both sides do it. The result of both the liberal and conservative approach is that religious liberty is no longer treated as an inalienable right that limits the size and scope of the state. Rather, it's an attribute that earns individuals special disabilities. That is, the Lutheran school can't get the playground, or special privileges. The religious individual doesn't have to obey by the otherwise valid law. Rather than limiting the state's authority, the state ends up taking authority over religion, and judges use that authority to dole out special privileges or special disabilities. If we follow the founders' natural rights philosophy on which this country was founded, it would lead to a significantly different approach to constitutional law. It would not lead to a wall of separation, nor would it lead to religious exemptions from otherwise valid laws. It would lead to a much more limited role for judges which allows more room for the people to legislate as they think best. A jurisprudence consistent with our founding philosophy would prohibit government only from exercising jurisdiction over religious exercises as religious exercises. For the Establishment Clause, this would mean the state can't give its power to religious groups. The state can't act like a church. The state can't write prayers for students and make the students recite them. The state can't appoint bishops. It can't make rules for who is or who cannot be a member of the clergy. The state cannot advance religious tenets under its own name. The state can't delegate its authority to churches. What an establishment was at the time of the founding was, it wasn't government funds going to religious groups. It was the government giving its power to religious groups, to churches, and then the churches could then tax their members. That is, the taxes, the religious contributions were no longer voluntary. If you joined a church, the church assigned you a tax. If you did not pay the tax, the church had the government's power to compel you to pay it. It's not government funds going to religion, it's government giving its power to religion. That's what an establishment of religion was. Okay. In the founders' approach, if government policy pursues a valid civic purpose, and if religious individuals or institutions qualify to participate in whatever government programs at issue, they qualify under non-religious criteria, they wouldn't be disqualified on account of their religious character. That was cumbersome. No special disabilities on religion is the founders' approach. The founders' approach, unlike the liberal Supreme Court approach, would not read the Establishment Clause to mandate discrimination against religion. So if Catholic schools or religious schools do a good job teaching math, or if they need help to do better job teaching math, government can fund math teachers. If a state that has a program to make playgrounds safer, religious schools can participate in that too. The same kind of equality before the law principle would apply to the Free Exercise Clause. Following the founders would only mean that government could not punish or prohibit individuals for exercising their religion as religious exercises. So government can't punish you for praying, it can't make you pray. But the founders' approach would not make religious citizens exempt from otherwise valid laws. Founders certainly recognize that the rule of law is not perfect, and in some circumstances, exemptions might be granted from the law. Classic example is Quakers and military service, or pacifists. Conscientious objectors is the term we use today. But those exemptions were discretionary and done by the legislature. They're not mandated by the Constitution. This more limited understanding of the constitutional right of religious free exercise would be resisted by most social conservatives today, who, as I said before, understand the right of religious liberty to be a right of special privilege or a right of exemption. The founders' approach meant religious liberty was a right to be equal before the law. It's our circles. I don't know, are those helpful? The natural rights approach draws relatively clear lines concerning religious worship and state power. Government doesn't have any power over religious worship. It would have the judiciary police these relatively clear lines. The judicial question would be, does the state have authority to act in the way it's acting? The judicial question would not be, let's evaluate the effects of this law, and do we like or dislike the effects? That's not the role for judges. Okay, let me try to conclude. I think church-state issues remain in the front of our culture wars, in part because it's easy to see the unfairness of each side's position. Court liberals seek to prevent religious individuals from participating in our civic life on equal terms. They unjustly penalize religious citizens to advance an exaggerated notion of freedom from religion. Court conservatives seek to exempt religious individuals from the civic obligations of following duly enacted law. They privilege religious citizens to advance an exaggerated notion of freedom for religion. Adopting the founders' approach certainly would not satisfy everyone. Liberals would have to accept that freedom from religion means that one cannot be coerced to go to church, not the elimination of religion from the public square. Conservatives would have to accept that religious freedom only means that government cannot impose targeted disabilities on religion as such, not that religious individuals are exempt from otherwise valid laws. In truth, the founders' approach would satisfy no one today. This talk is not a popular talk especially among legal academics. The founders' approach would emphasize legislative compromise. It would downplay the role of the judiciary. It would especially downplay the role of special interest law firms. Here's one thing that both liberals and conservatives have in common. When the judicial tests, the legal tests are complicated and have to be litigated, who gains the most power? Not the people, but special interest law firms. Religious and non-religious citizens, in the founders' understanding, would have to learn to get along better, attempt to work together, and adopt laws that in justice can apply to everyone equally. Social conservatives would have to focus on preventing laws they find oppressive, not in getting exemptions from them. It's possible that today, given all the changes in society, that the founders' approach would only inflame political disagreement. That today, religious and non-religious citizens are so far apart that really the best that both sides can hope for is to defeat the other side in court. But the winner-take-all approach has not worked well for anyone. Too much is at stake on who has 5 votes on the Supreme Court. For 3 generations, really 4 generations, that dates back to the first modern church-state decisions, both sides have ignored the founders' approach. The result of both liberal and conservative jurisprudence is to inflame our culture wars. Okay, I should return to the cases I started out with. If we follow the founders, Jack Phillips, right, the owner of Masterpiece Cake Shop, would not receive a constitutional exemption from Colorado's non-discrimination law. So if the people, in this case, the people of Colorado, if they say, look, if you want to do business in this state, you can't choose what customers you serve and not serve, all business owners, including Jack Phillips, would have to follow the law. So if Jack Phillips or religious conservatives think that he should not have to design a custom cake for a gay couple, they would have to make their arguments and persuade their fellow citizens that non-discrimination law should not be extended in that way. Think of the arguments they might use to advocate for that position. They could appeal to their own narrow convictions, or they might appeal to more general principles of freedom of association or property rights. They might try to make common cause with progressive small business owners and explain that if a progressive gay couple owned a custom t-shirt printing business or a restaurant catering business, that progressive couple should not be made to make t-shirts or cater a church banquet for ideas or individuals with whom they disagree. In short, if religious citizens or any citizens think law would be oppressive when applied against themselves, they would need to become more political and less legalistic. That's just a fancy way of saying they'd have to appeal to their fellow citizens and explain why this law shouldn't be passed. Okay. These types of arguments are policy arguments. They're not legal arguments. And in our original constitutional design, it is the people who deliberate upon these matters. Now, I could do a whole nother lecture on Federalist 10 and explain how the multiplicity of interests, at least in the founders' thought, leads to a more just political outcome. In fact, this understanding of church-state jurisprudence and its narrow focus complements the Constitution's Republican or Democratic design. Okay, what about Joe Kennedy, the coach who prayed on the 50-yard line? If a school district does not generally restrict a coach's expressive behavior after games, they could not single out religious prayer for disability. Again, the founders' approach is that you can't target religious exercises as religious exercises. So a school district can't single out and ban prayer after football games. It's doubtful that the school district could prohibit any disruptive behavior. Just think about it this way. If Coach Kennedy or any coach took a knee after the game or during the national anthem to protest military action or systemic injustice, that expression clearly would be protected by the First Amendment's free speech clause, and in the case of Coach Kennedy, the free exercise clause. So for the founders, religious liberty didn't mean primarily freedom from religion or freedom for religion, as those positions are understood today. Rather, for the founders, religious liberty meant that all individuals of all religions or of no religion could be fellow citizens. Religious freedom meant all citizens, religious and non-religious, would be treated equally under the law. It meant that government had no power to target religious exercises. It has no power because religious exercises as such are an inalienable natural right, and we do not give government power over our religious exercises. Okay, whether we follow the founders today is really up to us, but we can't follow them if we don't understand them. I suppose I've advocated for the founders' approach, but really my intention is to present that approach to you. If we understand it better, we can evaluate its merits or its lack of merit for today's world. But that's a conversation we should have together. So thank you very much. Happy to take any and all questions. But Rick, you'll have to tell me how much time we have. In my center, we have a tradition. I'll impose it on you. We always let undergraduate students ask the first questions. So any undergraduates? Yeah. Tell me your name and your place at school and yeah. Eric. Okay. Yeah. Eric's question is, how does using the Masterpiece Case Shop, where's free expression in that? And you could say, is this compelled expression? That's what the question gets at. Could be. That wouldn't be a religious liberty case then. It would be a free speech case. That'd be a different set of arguments. Commercial speech might not have the same protections as non-commercial speech. So that'd be one issue. The real issue here is the older approach, the common law approach was, so Colorado's non-discrimination law extends to Masterpiece Cake Shop because they had an expanded notion of public accommodation. But a small business didn't used to be a public accommodation. And the modern understanding of public accommodation is if you're open for business. But the older understanding was not that. So in the older understanding, you might, if you're open for business, you might have to sell. If you have something for sale, you're open for business on the shelf. Anyone who can walk in the store should be able to buy it. But you don't have to do customized services for anyone you don't want to, for any reason you don't want to. Right? You don't have to cater. You don't have to print the T-shirt. You don't have to design the cake. That actually gets to freedom of association and property rights. Those would be, now I'm not saying the case would be decided one way or the other, but it's not primarily a religious liberty case. Could be free speech, could be freedom of association, it could be private property. All right. Okay. Other undergraduates? Yeah, please.
I'm a political science major. I was just wondering, how much of this disconnect do you think we've seen from the founders' perspective of religious freedoms, what we have now, is just because of the procedural law we do have in the state? Like, how much of that change do you think is just from that over time? or versus like a specific adamance to control how religious.
Yeah, wait, just say a little bit, when you say procedural law, what do you have in mind? I'm not sure I follow that.
Law and different doctrines that are determined by actual court cases as they happen, like precedent.
Oh, by precedent. Well, no, it's a good question. I would say the early precedents, especially around the 1940s, starting then, themselves follow a critique of natural rights thinking. So let me just give you a quick snapshot. Read the Gettysburg Address or the second inaugural, or really most of Lincoln's speeches. Lincoln is always talking about the Declaration of Independence and natural rights. Then go read Woodrow Wilson's speeches. So these are presidents roughly 50 years apart. Woodrow Wilson said about the natural rights part of the Declaration of Independence, we hold these truths, that it shouldn't be read. Woodrow Wilson said, we no longer believe in natural rights, right? Because rights are not a product of nature, human nature. Rights are a product of the state. Woodrow Wilson's campaign theme was the new freedom. Right? The old freedom was natural rights freedom and limited government. The new freedom is, no, we understand rights are created by government. So there was an intellectual critique among political scientists, some here in Madison, that led to the precedents you have in mind. Yeah, please.
I'm Owen. I'm studying agricultural management. I was just curious, like your opinion, you said like you think it'd be best to have the founding fathers approach because that'd be more political, not as much law related. I'm just curious, like as countries can just like be more divided, do you see like the founding fathers approach like less and less likely? How do you see that playing out?
Yeah. There's no doubt the country is more divided. But I think in part we're more divided because we don't try to work with each other. Because so much of our politics is made into what people call lawfare. Right. We hire lawyers and fight in a winner take all instead of compromise. Right. I actually think most people are Joe American's relatively sensible and willing to compromise and might disagree, but I'm going to win a little bit here, I'm going to lose a little bit there. Right. I'll give you an example. This example actually happened when I was testifying before Congress, and this senator asked, not me, but someone else who was testifying about, could there be prayer in this state-funded nursing home? And, it was a hypothetical, and would this be, if they prayed before the meals or prayed together, would that violate the Establishment Clause? And the law professor who was commenting said, well, we'd have to get lawyers involved and figure out, because we won't want the prayers to endorse religion, but we'd want the residents to, who want to pray. And she went through all the legal arguments and the complications. And I'm sitting there thinking, just let the residents have a meeting and they'll figure it out. Why should they hire lawyers to figure out if they can pray in their own home? Only a lawyer would think you should hire a lawyer to figure this out. So I accept the polarization, but actually democratic politics tends to, just think of when you get to know people you disagree with and you spend time with them and you argue with them and you have a common project. Do you tend to, you might not agree with them, but do you tend to think they're less bad? I think that's the common experience. So maybe we just need to work together more on common projects. Maybe we work together more on common projects and we realize we really can't stand each other, but I don't know. Okay, sir, you've been waiting.
Okay, thanks.
Yeah.
Yeah, my name is Mike Odin, and I'm retired ABD from the history department here. Isn't it important when we talk about what the founding fathers were thinking? Although it's often not done, but shouldn't we look at what was going on in England during the period? I mean, if we look at England during the centuries leading up to the American Revolution, there was a lot of religious instability, to put it mildly, starting with the Reformation, and then for the next 2 centuries, there was a shift back and forth and balance of power between the Church of England and the Catholic Church. And a lot of people who burned or hung or whatever lost their lives because of religious disputes in England during that period. So were the founding fathers probably desirous of avoiding a situation where the religion, everybody would have to change their religion depending on the religion of the new president when one came in and then another one came in, and avoid that type of potential violence and instability?
Yeah, did everyone hear the question? The question, just for the recording, is, what about English history or maybe even European history? And what does that have to do with the founders' approach? And weren't they learning the lessons of the old world? That's not your term, but the old world, and saying, look, we should do things differently here. And the answer is obviously yes. So I agree with everything. In fact, if the most obvious place to start, if you want to know what an establishment of religion is, well, what was an establishment of religion in England, right? The Anglican Church is the established church, or colonial America, which is part of England. So I agreed, 98%. The 2% difference is when the founders spoke about religious liberty, they called it an inalienable natural right. Now, Locke uses the term natural rights. As far as I can tell, he never uses the term inalienable natural right. So there's an intellectual heritage there. But the founders are doing something different in their natural rights constitutionalism. And you see this language of natural rights really emerging in the 1770s. And where it really emerges in legal documents is actually the state constitutions, the first state constitutions and the first state declarations of rights. Now, granted, there's a rich intellectual tradition, which a social compact tradition or social contract tradition that dates back to Locke for sure. But the founders were also doing something new in terms of government. That's that inalienable natural rights. Yeah, way in the back, sir, please.
Question related to your response about Woodrow Wilson, and it has to do with this idea of inalienable rights. The founders were working from a premise that there were certain rights endowed by a creator. Okay, fair enough. You're advocating for a return to the founders' understanding of alienable and inalienable rights. But the paradigm philosophically and in terms of government shifted over the 230 some years since the Constitution was written. And we moved to, in the middle of the 19th century, a more scientific, evidence-based understanding of how the world works. We've now entered a period where expertise is not particularly loved. So, who knows what's next, but a return to a philosophy that's 230 some years old seems to me to be kind of how do we start with something like that in a context where our understanding of how the world works is so different?
Yeah.
So I guess the real question is, if we're not willing to grant that we can go back to a notion of natural or inalienable rights as established by a creator, given the secularism of American culture and society, what's the nearest equivalent?
No, that
without dragging a creator.
Yeah. No, that was really nicely stated. What you articulated was the essence of Woodrow Wilson's argument. It's not that you said, well, for a long time, we've thought differently. Woodrow Wilson said, look, scientific expertise is revealing. I mean, he was saying we need to change. You're right on the same page. I would say this. Let's use the idea of scientific expertise. What is the foundation of the idea that all human beings are created equal? In the older understanding, to use quote Lincoln would say, our ancient faith is all men are created equal, all human beings are created equal. It's a principle of justice, right? that principle, natural right, that's what we mean by natural rights. How are we equal? We're all equal in our natural rights. And it is true Woodrow Wilson abandoned that. What also happened when we abandoned that was the worst form of quote unquote scientific racism we have ever seen. So it's not clear to me that there has been progress. And it's not clear to me that things are better now or we know better. In fact, we have no, if we abandon natural rights, we have no philosophical framework on who is and who is not equal. The most sophisticated and interesting philosophical minds, and I have two people in particular in mind, Richard Rorty, philosopher at the University of Virginia, and Peter Singer, right, perhaps the most distinguished philosopher at Princeton. Rorty's position, and they agreed with Woodrow Wilson, and we can't go back to natural rights. Rorty's position was, we just have to assert our position. He says there is no foundation for a commitment to equality. That's just what we believe. Well, that's about as flimsy a foundation as you can have, because not everyone believes that. Peter Singer, again, endowed chair at Princeton, says the same thing. Look, we can't go back. Peter Singer also advocates his position shifts from here to there. He says, look, if we're really consistent in context of abortion, parents should be able to terminate their children somewhere between 4 weeks or 2 years after they're born. That doesn't sound like progress to me. For those interested in this question, you should look at what the American Breeders Association was. Mainstream association. Because what happened about 100 years ago when we gave up natural rights is, well, if we're not all equal, then we should use science to decide who should and should not reproduce. And experts will decide who should be allowed to procreate and who should be sterilized. Supreme Court sanctioned that. That's what to give up natural rights leads to. It's what it did lead to in practice. If you're interested, look up what the eugenics movement is. And it was scientific. I'm certainly willing to entertain alternatives. We haven't come up with one in 100 years. Let's get some more students. Any more student questions? Oh, please, yeah.
I'm Luke. I'm a law student, so I take your law conference all the time.
Yeah.
And just a counter question. If let's imagine the Supreme Court judges, like you're on the Supreme Court, and you were to write a test that would basically equate what the founders would envision. I mean, well, how would you write that test?
Yeah. There's a book you could buy, and it's in chapter 7. It's a jurisdictional approach. The basic test is, I'm going to summarize to make it simple. For the establishment clauses, does the state act like a church or delegate its power to the church? So a very good example is there's one state that established a church in U.S. History. It's the South Carolina Constitution of 1778. And if you read that, in the South Carolina Constitution, it says that the Protestant church is the established church of the state of South Carolina. And then it listed 5 articles of faith that every church had to believe in to be recognized in the state, to have legal recognition. It's kind of what we call non-denominational Protestantism today. And the state had, it said, there's an oath of office for ministers and how ministers were selected. It was all prescribed in law in the state constitution. So the quick formulation is, a state can't act like a church and it can't delegate its power to church. That's the taxing. I'll cover that. For the free exercise clause, the test would simply be, does the state action take cognizance of religious exercises, qua religious exercises? Right. So you can't ban worship, you can't make anyone worship, can't ban religious practices as religious practices, you can't prohibit religious practices. That rarely happens. It does happen sometimes. I'll give you a recent example. I'm from the state of Washington. That's where my mom moved when she left Fond du Lac. During COVID, the Governor Inslee of Washington, issued a regulation on how to distribute communion. I mean, it wasn't how to distribute food. It was how to distribute communion during a religious service. Look, during a pandemic, the state, or just in general, the state can have rules on how you serve food. That's no problem. But the governor of Washington can't make rules for religious services. Again, this was not a generic regulation that applied to food services or distribution of food or distribution of drinks. It was how to distribute communion. So it does happen. In practice, most church state, there wouldn't be that many constitutional violations, and people get nervous about that. That translates into the people get to govern themselves. Okay, you've been waiting a long time, please.
Yeah. How do you think that the founders' understanding of natural rights coincides with more contemporary answers of like say the UN's like Declaration of Human Rights? Like, would you say that those are founded on the same principle? Would you say they're founded on different principles, but they have the same core idea? Like, how do you view that?
Yeah, no, that's a really nice question. It's not easy to answer because as the authors of the UN Declaration of Rights themselves said, I mean, Jacques Maritain is the person I have in mind, but said one of the beauties of the UN Declaration of Rights is we can agree to the rights without agreeing to their foundations, right? So it depends what you think the foundations are. Right. So I can't really answer the question because the authors themselves tried to have the rights without foundations. In practice, I think that means that they're quite malleable and they can mean different things at different times. Again, it all becomes, well, who's empowered to interpret these things? So it's a great question. There's just, I don't know that it can be answered. Do you want to follow up? Is that?
Yeah, I guess like would you say that that's like a more efficient design in practice for the idea of natural rights than with the founders? In the Constitution, which is the founders method is more like of the rights with the foundation is more effective in practice.
Well, I wouldn't use the standard of efficiency, but the question is what can retain their authority? What approach can retain its authority? So the dominant political theorist of the last 50 years is a gentleman named John Rawls, a Harvard political theorist. And his idea was, look, we can have modern secular liberal government without agreeing to rights, without agreeing to their foundations. And in a way you could say, well, the proof is in the pudding. It's kind of worked. But it kind of works until it doesn't. What happens if the people stop agreeing? It's kind of like asking, well, is it easier to get agreement when the people agree or when the people disagree? Well, obviously when they agree. But where do you go when they disagree? That's when you have to go to fundamental principles. Let me give you a real life example from our history. So I referenced Abraham Lincoln. The question between Lincoln and Douglas, Stephen Douglas, and the Lincoln-Douglas debates was, what do we do with slavery in the territories? Slavery was a state question, except in the federal territories. Then it was a national question because Congress governs national territories. And they both said, well, we should go to principles, right? They just had different understandings of the true principles of government. Lincoln's true principles were natural rights principles. We're all equal. Therefore, slavery is unjust. The Constitution allows it, right? Because it allows states to determine, and some states adopted slavery. It's a compromise with our principles. It's a fundamental injustice, but a constitutional protected one. That was Lincoln's position. Stephen Douglas's position was the foundation of rights is democracy. because we decide we have rights. That means on the question of what to do with about slavery in the territory, it's up to the people of every state and territory. Stephen Douglas says, the people decide. Isn't that democracy? So the people decide who is and who is not a person. So he says, if the territory of Nebraska wants slavery, they can have it. If they don't want slavery, they don't have to have it. The people decide who gets and does not get rights. The people decide what is and is not wrong. As you can sense, I don't think that's a good way to decide. We have to have some foundation somewhere. Our tradition is one of natural rights. There could be other traditions. When we articulate those traditions, we can evaluate them philosophically, prudentially, expeditiously. But right now we have foundations versus no foundations. For your students, non-foundationalism is the dominant school of philosophical thought. I think it can lead to disastrous consequences. You have to tell me when we should stop. I'm happy to. 2 more questions. Okay, ma'am.
I think it would have been better. Founding fathers would have written freedom from a specific religion. Instead, we tend to think of things as religion versus non-religion. The truth is, most people practice religion, and so there were severe consequences for people who didn't in the beginning of this country. But more specifically, it is there used to be prayer in school, public schools, but it wasn't until a certain time when Catholic kids going to school, the people in the clergy didn't believe that they were getting the equal rights to the kind of prayers that they said. So they founded their own schools. And that's how the Catholic system developed in this country. And I think it was that it's more, we can't regulate any kind of specific input in the public sphere. And I think it rings, when you have this debate, it sounds like you're either religious or you're not religious. You either believe in something or you're an atheist. And people that are religious have a real problem because they say, I want to see God in the public sphere. And if God isn't there, that side wins. The atheist wins. And the atheist says, I don't want to see that. But we think we can do a neutral by not seeing anything. And then this side says the atheist wins because the absence of something is a promotion of something. But then I think the argument then goes to say, we can't regulate it. And so you say you're from Fond du Lac, if you go to St. Agnes Hospital, and a woman goes into the hospital and she wants birth control, she's gonna get that birth control. It's a funded, they get public funds in St. Agnes. And they serve a lot of people within Fond du Lac Health. And if you're a Lutheran, you're gonna say, of course I'm gonna go in there and get birth control, but the Catholic Church has to swallow part of that as one of their beliefs in order to get that funded. So you say, even within religion, it's more of a thing within religion to say what kind of religion you're gonna have if you put it out in the public and where you put it. And I think that sometimes in our terms, we look at it as people as a non-belief versus a belief. And I think the founding fathers, because a lot of them were deep thinkers, with no other way to say it, they thought of it maybe a little bit like we think of it today. But I think the common people that they were writing the Constitution for thought of it as a freedom from a specific religion versus freedom from religion.
You said a lot. There's much I agree with, much we'd have to explore more.
You know what I'm
Let me
saying? They can't say an inalienable right. It's signing on who gave you that, what God gave you that right is very different.
I think the founder's approach more generally is, let me answer it this way. We create the political community and the government and the constitution that operates it. And we don't give the political community authority over everything. We reserve that authority for ourselves and for our churches. So think of it in terms of who can and cannot be a citizen. There should not, and is incompatible with our Constitution, to have a religious test for citizenship. Doesn't mean religion's not important. It just means in being an American, you you can be religious or not religious. I think that's the main founder's approach. And that's in part because of the experience of when the stakes of politics are too high, they become too bloody. So let's just agree not to agree about everything and leave some things out of politics. If you go back to the circles, right? It actually, if we, maybe I'll make this the last thing. I'm sorry if there's another question. I'm happy to stay and answer. Our politics doesn't have to determine everything about our lives. And it might be the less our politics determines, the better we can live together as a people. That's a political opinion, not a legal one. But I think it's actually reflected in our Constitution. Happy to take any more questions. And thank you very much. Your questions were excellent.
Thank you all for coming. Our next event is on our website. It's csld.wisc.edu. And it will be a longer panel with 4 discussants. And it is called Black Conservative Political Thought. Please check our website if you'd like to come over and participate in that. Thank you all for coming. Thank you for your presentation. Who you are? I'm retired. Very good.